Today's speaker is Robin Blumner. And I hope if I got your name wrong, Robin, I apologize. Blumner?
Blumner.
If I got your name wrong, I apologize. She's a lawyer, journalist, and civil rights expert, and the current president and CEO of the Center for Inquiry. Is also the executive director of the Richard Dawkins Foundation for Reason and Science. She earned a BS from Cornell University and a JD from New York University School of Law. Previously, Robin was executive director of the American Civil Liberties Union of Florida, and prior to that, the ACLU of Utah. She spent 16 years as a nationally syndicated newspaper columnist and editorial writer in Florida. We do welcome Robin today and look forward to hearing what you have to say. Robin, it's all yours.
All right. Well, thank you. And good afternoon to everyone. It's a pleasure to be with you today. And I'd like to just start off with a special hello and thank you to Frank Robinson. Frank is a benefactor to one of CFI's most consequential programs called Secular Rescue. It's a life-saving program that's been called an underground railroad for atheists. So when atheist activists in places like Bangladesh, Pakistan, Iraq, find themselves in danger due to their activism, Secular Rescue helps get them to safety. And Frank has been instrumental in allowing us to do that work. And I'm sure you all know about Frank's terrific blog, The Rational Optimist, which really has been a lifeline to me during this election season. As a former columnist, I know how challenging it is to write on a regular basis at such a high quality. And Frank, kudos to you for always being interesting and almost always being right. But today I've been asked to speak about the assaults on church-state separation from the Trump administration and the Supreme Court. And when the blurb for this talk was conceived, there were 5 votes on the High Court that would dependably vote to undermine the separation of religion and government and promote religious privilege. Now, with the addition of Justice Amy Coney Barrett, there are 6 such votes. Also, of course, we didn't know whether the Trump administration would be with us for 4 more very, very long years or a mere 75 more days. And I'm happy that, of course, that it's the latter. And I'm going to apologize in advance that this talk is a little bit of a downer at a time when many of us feel like celebrating. But we do need to know what we're up against, both in the court and with the administration. So I'm going to speak today about what the founders meant by the Constitution's religion clauses and how that vision is being irreparably damaged today by the court's conservative bloc of justices. We all know how the First Amendment begins, quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." The Establishment Clause and Free Exercise Clauses were meant to be read in tandem. The founders, and in particular James Madison and Thomas Jefferson, who were the chief architects of the religion clauses, were designing a government where religion would have a role separate and distinct from government. The Establishment Clause would keep government from entangling itself with religion, either to its benefit or to its detriment. And the Free Exercise Clause would protect freedom of conscience wished. This was a deliberate break from the model in Europe, where the founders were well aware of this history and the bloody religious wars that this model engendered, particularly between Catholics and Protestants. And they also knew well the way early immigrants to North America were treated by people of other faiths. So most notorious is what the Massachusetts Bay Colony did to the Quakers. In mid-17th century, the Puritans passed laws against Quakers, making their mere presence a capital offense. So if you were harboring a Quaker or you attended a secret Quaker meeting, you would be subject to very severe penalties. For instance, if you were a woman and this was your second offense, a hole would be bored through your tongue. And if you were a man and it was your second offense, an ear would be cut off. A third offense brought hanging, regardless of gender. So it was against this not very long ago history that the establishment and free exercise clauses were born. And we don't have to guess at what was meant, since Jefferson and Madison left behind significant writings on the subject. Jefferson made it clear that he wished to give freedom of conscience a very wide berth with no government involvement whatsoever. In 1787, Jefferson published his Notes on the State of Virginia, in which he wrote, quote, "The legitimate powers of government extend to such acts only as are injurious to others, but it does me no injury for my neighbor to say that there are 20 gods or no God. It neither picks my pocket nor breaks my leg." We all know about Jefferson's letter to the Danbury Baptists. Written on New Year's Day in 1802, President Jefferson assured the Baptists that the First Amendment had built, quote, "a wall of separation between church and state," unquote. But perhaps less familiar is James Madison's Memorial and Remonstrance against religious assessments. This was Madison's argument against a proposal in the Virginia legislature to fund Christian ministers and ministries with taxes. And Madison wrote that religion is not something that should be forced on the people by government through a tax levy, and that by providing taxpayer support to religion would end up corrupting religion. Now that argument ruled the day, and the measure was defeated. So Madison and Jefferson were situating the United States as a secular democracy, technically a republic, where the government does not prefer one religion over another religion, where it does not prefer religion in general over no religion, and where tax money does not flow into religious coffers. Frankly, this is why I find the so-called originalists on the Supreme Court to be so disingenuous. The conservative wing of the High Court now consists of Justices Samuel Alito, Clarence Thomas, Brett Kavanaugh, Neil Gorsuch, Chief Justice John Roberts, and our newly minted Justice Amy Coney Barrett. And they are actively working against the ideals and values that were baked into the American experiment on religion. These jurists seek to grant religion special and ahistorical standing under law. They seek to excuse religious people and businesses from laws that apply to the rest of society if those laws go against a religious sensibility. They seek to allow government to engage in sectarian religious exercises, whether that be prayers at government functions or the prominent display of sectarian symbols on government property. And most distressingly, they are demanding that taxpayers subsidize religious entities whenever government subsidizes similar non-sectarian activities. The goal of this group of justices is to do to the Establishment Clause what Grover Norquist wants to do to government, which is to shrink it down to a size where it can be drowned in the bathtub. And unlike Grover, who has no official power to do the deed, these justices do have the power, and they have the motivation, and they are doing it. So how do we know this about Justice Barrett, since she's brand new to the court? Well, her background and writings suggest she will be very much in the mold of the justice that she clerked for, who was Antonin Scalia. So in public speeches and in cases that he's ruled on, Scalia made his contempt for the non-religious very clear. So there was a 2013 interview he did with New York Magazine, in which he stated bluntly that the devil is real. And when he was asked what the devil is up to these days, Scalia said, well, not so much demonic possession as the devil is busy getting people not to believe in God. So basically the devil, according to Scalia, is busy creating atheists. Scalia's antipathy towards atheists also found its way into legal opinions. In 2005, Scalia wrote a dissent in a case when two framed Ten Commandments were ordered taken down from two courthouses in Kentucky. He said their removal contravened, quote, the interests of the overwhelming majority of religious believers in being able to give God thanks and supplication as a people and with respect to our national endeavors, unquote. So his argument was basically that the First Amendment does not forbid government from preferring religion over non-religion, that it could prefer religion and it could say so loudly. And I think there's very little chance that Barrett will break from this. And I think that's precisely why she was chosen for the seat that previously was occupied by Ruth Bader Ginsburg. I mean, Barrett was a longtime faculty member at Notre Dame Law School, a member of the university's Faculty for Life group. She signed a 2015 letter to Catholic bishops that affirmed, quote, the value of human life from conception to natural death. Barrett is a member of People of Praise, which is a majority Catholic group that looks a lot like evangelical Christians, including speaking in tongues. In 2006, Barrett, in a commencement speech to Notre Dame law students, told the audience, quote, keep in mind your legal career is but a means to an end, and that end is building the kingdom of God. During her confirmation proceeding, Barrett refused to say whether the 1965 case of Griswold versus Connecticut was correctly decided. She demurred, saying it was unlikely to be overturned. Now, this is the case that established the constitutional right to privacy. It said that the Constitution protects the intimacy rights of married couples and their access to contraception. It struck down a law in Connecticut that had prohibited any person from using, quote, any drug, medicinal article, or instrument for the purpose of preventing conception. So contraception was illegal in Connecticut until 1965. Senator Chris Coons of Delaware, who asked Barrett about Griswold, responded to her sidling past the question by pointing out that during their confirmation hearings, Justices John Roberts, Samuel Alito, Brett Kavanaugh, and Elena Kagan had all spoken approvingly of Griswold, but Barrett would not. And the important thing to know about Griswold is that it provides the reasoning, the constitutional underpinning for Roe versus Wade. As a judge on the federal appellate court, Justice Barrett only ruled on one significant case involving religion, but it suggested that she saw religion as occupying a special place in law and that religious actors could receive special treatment. The case involved a limit on gatherings due to the coronavirus. The Illinois governor, who was a Democrat, had limited gatherings to 50 people, but made an exception for religious groups, allowing larger gatherings. The state GOP sued on the grounds that religious speech cannot be given preferential treatment over core political speech, such as Republican Party gatherings. And Barrett joined a 3-judge panel that said religious speech occupies an elevated position and therefore a beneficial exception to limits on gatherings could stand. The panel said that, quote, speech that accompanies religious exercise has a privileged position under the First Amendment. Last Wednesday, Barrett participated in her first oral argument in a free exercise case. It's a case that almost assuredly will add to this trend of giving religious sensibilities veto power over the laws that apply to everyone else. The case was Fulton versus the city of Philadelphia, and it involves the foster care system in Philadelphia. So the city refused to renew a contract that it had with Catholic Social Services to evaluate prospective foster parents because Catholic Social Services would not approve same-sex couples as foster parents. After its contract was canceled, Catholic Social Services sued the city on the grounds that it had a First Amendment right to be paid with tax dollars and apply its own religious criteria to the provision of services. And if Catholic Social Services wins, and I listened to the oral argument, and I think they will, it would mean that religiously affiliated contractors who perform government functions could limit who they serve as a matter of a constitutional right. Homeless shelters, food banks, job training, medical services could refuse to serve LGBTQ families, as well as anyone else who is not of the same faith as the service provider. And this is not hyperbole. In South Carolina, Miracle Hill Ministries was granted a waiver by the Trump administration so it could deny foster care approvals to not only same-sex couples, but to any non-Christian couple as well. And it was paid, they were paid with tax dollars. So, I mean, you could see the signs that will go up if this is approved. You know, no Jews, Muslims, or atheists need apply. And we will be forced to pay for it. But even before Justice Barrett came to the court, the Establishment Clause was being battered into submission. Over the last few terms, the High Court has rewritten Establishment Clause jurisprudence to a point where church-state separation is now considered open hostility toward religion and is not to be tolerated. In June 2019, the court ruled a very disappointing 7-2 in the case of American Legion versus American Humanist Association. I'm sure many of you are familiar with this case. The AHA was challenging an immense 40-foot Latin cross that sits on a busy intersection in Bladensburg, Maryland. It's a World War I memorial, and it's maintained through by government with hundreds of thousands of dollars in tax money. The cross was allowed to stand through a confusing amalgamation of at least 4 different rationales from a variety of justices. The only 2 dissenters were Justices Sonia Sotomayor and Ruth Bader Ginsburg. And the one overlapping factor from the various concurring opinions seemed to be that the cross had historical importance. There is a sense on the part of 7 justices, including Justices Kagan and Breyer, that religious symbols are part of America's heritage and should be protected as such. So to my mind, this case dooms any effort to remove religious monuments from public property, certainly if they've been there for any length of time, but even possibly new monuments. And while this is infuriating to secular people who are excluded from these government expressions of faith, it's actually not the most consequential damage that's been done to the wall of separation in recent years. That prize goes to a case decided last term, Espinoza versus Montana Department of Revenue. So in that schools, and in program in Montana that kept tax money out of religion, as James Madison urged, are now, under this Supreme Court, a form of unconstitutional religious discrimination. This case changes everything about the relationship between religion and government, from hands-off, each occupying a separate sphere, to religious hands in government pockets as a matter of right. And this is the school voucher monster coming home to roost. In Montana, 94% of private schools are religiously affiliated, and that's a typical percentage in most states. Church-state separation proponents have worked literally for decades to keep government money from children. And now with the Espinoza ruling, the pro-voucher people, they have what they want. And when this case was oral, guess who was in the audience? Education Secretary Betsy Devos. For those of you not familiar with Betsy Devos, before becoming Education Secretary in the Trump administration, she used her personal family fortune to fight against public education and to promote the funding of private schools. As Education Secretary, she has backed multiple voucher schemes. And most recently, she attempted to divert $180 million that was to go to poverty-stricken Now, there's another troubling line of cases. Perhaps most famous in this line of cases is the 2014 decision in Burwell versus Hobby Lobby. So this was the case that involved the contraception requirement under the Affordable Care Act. Employers of a certain size are required to provide health insurance to employees. There was already an exception. For instance, a Catholic diocese would not have to provide that coverage. But the question in Hobby Lobby was whether a private business not connected to religion in a formal way could refuse to provide its employees a benefit that was required by law. In a 5-4 ruling, the court said that a family-owned business had the right to have its religious beliefs override federal law and employee interests. Ruth Bader Ginsburg wrote a dissent that wondered aloud about employers who, due to their religious beliefs, wanted to reject coverage for vaccinations or medicine derived from pigs or antidepressants. We now occupy a world in which an employer's religion can control a workplace for their employees. And I wonder what will happen when a Muslim employer insists that no food is allowed to be consumed by employees during the day, during Ramadan, or women employees must wear headscarves on the premises. I don't think that day is far away. And last term, the court further disadvantaged those employees who work for religious employers by making it impossible for them to sue for discrimination. In a case called Our Lady of Guadalupe School versus Morrissey Bayou, the court ruled that teachers at a Catholic school were barred from being able to sue their employer for employment discrimination. The suit was a consolidation of 2 cases. In one, a teacher lost her job after being diagnosed with breast cancer, and she was prevented from suing for disability discrimination. The second was a teacher who was barred from suing for age discrimination. The court justified this by expanding the ministerial exception, which exempts religious institutions from anti-discrimination laws when they choose their leaders. This is a judge-made exception to employment laws that was created to keep government from second-guessing who can get hired as a priest or a rabbi or an imam. In that context, I would argue that it makes some sense. But in Morrissey, the court stretched the definition of a religious leader to include essentially all teachers at religious schools. This precedent could easily apply to people working in religiously affiliated universities and hospitals, stripping them of legal protections. And then there is the case of Masterpiece Cake Shop, which is the case involving a baker who refused to serve a same-sex couple that wanted a wedding cake. In Masterpiece, the High Court overturned a discrimination finding against the religious baker by the Colorado Civil Rights Commission. The court said that the baker had been a victim of religious hostility by the commission. So we don't yet know how far the Supreme Court will go in allowing proprietors to refuse to serve gay to refuse to serve gay customers in violation of public accommodation laws. But my guess is that almost any business will be allowed to do so as an exercise of religious freedom. So basically, there are two groups of people who are most at risk under this court's jurisprudence. First is all of us. Atheists, humanists, and the non-religious will be consigned to second-class citizenship because religious beliefs and sensibilities will be given precedence under law. And second, LGBTQ families who will be discriminated against with the blessing of this court, no matter how much the elected branches of government at the federal and state levels tried to prevent it. I expect a tsunami of litigation in the coming years that will cement this paradigm. One, government cannot exclude religious institutions when it comes to funding if that funding is open to other businesses or nonprofits. Two, unlike these other businesses and nonprofits that have to be transparent when receiving government funds, religious institutions will be held to a far lower standard of accountability. It will be justified as a way of keeping government from entangling itself in the internal affairs of religion. Remember that religions are exempt from having to file 990 tax returns like other nonprofits do, leaving their revenues and their funding sources opaque. And three, the government will not be able to require religious people, organizations, or businesses to follow non-discrimination laws or other laws of general applicability that conflict with their religious beliefs. And those beliefs, they will get to define for themselves and cannot be second-guessed by the government or courts. This formulation envisions a parallel set of institutions. On the one hand, secular businesses, and on the other hand, religious congregation, religiously affiliated schools, religiously affiliated social service organizations that will receive government funding, but will largely escape the scrutiny and the laws of government. This is a recipe to end our religious peaceful coexistence. The brilliance of Thomas Jefferson and James Madison's vision brought us 200 years of religious peace in America, and a group of Christian nationalists on the Supreme Court, who ironically claim to be speaking for the founders, are in the process of blowing it up. And while the High Court can do the most lasting damage to secular people, it's worth noting that the Trump administration has put a raft of Christian nationalists in positions of power and influence who are also causing serious damage to church-state separation. And I hope everyone has a chance to look over the timeline that CFI put together, because it's very specific in the way it describes the various ways that the Trump administration has worked to assault science and secularism over the last 4 years. But there are 3 cabinet secretaries in the Trump administration who are particularly motivated in this direction. I've already mentioned Betsy Devos at the Department of Education. In addition, there's Mike Pompeo at the State Department. He established something called the Commission on Unalienable Rights. And the final report of that commission stated, quote, foremost among the unalienable rights that government is established to secure from the founders' point of view are property rights and religious liberty. Now, this misses the point that the founders thought highly of a number of equally essential rights, such as freedom of speech and the press and due process rights. But the category of rights that the commission identified as most valued turns out also to be the ones that are seen as sacrosanct by Christian nationalists. And the most dangerous figure in the Trump administration today is William Barr, the Attorney General. He's Donald Trump's apparatchik who has demonstrated he will bend the law to advance Trump's agenda. At his core, he's a Christian nationalist who has repeatedly blamed secular people for the country's moral decline. To give you a taste of the kind of rhetoric that Barr spews, this is from a speech he gave at Notre Dame Law School last year. Barr declared that, quote, in the framers' view, free government was only suitable and sustainable for a religious people, a people who recognized that there was a transcendent moral order, unquote. He basically said that when religion is abandoned, so goes social order and morality. Barr said, quote, virtually every measure of social pathology continues to gain ground. Along with the wreckage of the family, we are seeing record levels of depression and mental illness, dispirited young people, soaring suicide rates, increasing numbers of alienated young males, an increase in senseless violence, and the deadly drug epidemic. He said, quote, this is not decay, this is organized destruction. Secularists and their allies among the progressives have marshaled all the forces of mass communication, popular culture, the entertainment industry, and academia in an unremitting assault on religion and traditional values, unquote. Of course, this is very scary that the nation's top law enforcement officer blames atheists and humanists for all the social pathology in the United States. And he blames us because we don't believe in the received wisdom from on high that he says is the only thing that keeps people in check. This is so delusional that it's hard to know where to start. As Richard Dawkins would say, if you take your morals from the Bible, you'd be a rather despicable person who supports genocide, infanticide, rape, incest, and slavery. But what makes Barr's rant so disturbing is that he has it exactly backward. If you track things like health, education levels, divorce versus intact marriages, opioid abuse, and other measures of social health, secular nations do far better than religious ones. And in the United States, secular leading states generally do better on those measurements than excessively religious states. William Barr is completely blinded by his own prejudices to what we know is true and borne out by evidence, which is that humanism, which combines the Enlightenment values of reason, science, and compassion, are the keys to human progress and social well-being. And we do have a moral order, not a transcendent one like he claims we need, but one grounded in empirical evidence that demonstrates through experience what kind of social rules and public policies provide people with the best quality of life, the most liberty, and the most broadly shared prosperity. In other words, a moral order that comes with the benefit of proof. And if Bill Barr wants to see moral depravity, he should take a closer look at the guy he's working for. A guy who has done immeasurable and lasting damage to one of this country's most successful Enlightenment values, that of keeping church and state separate. As Justice Sandra Day O'Connor said in a concurrence in a 10 Commandments case, quote, those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly? Why, indeed. Thank you very much for your kind attention, and I'm happy to take questions.
Robin, thank you very much. That was very interesting. As you say, it could be viewed as a bit of a downer, but we gotta remain grounded. Even though many of us on this call, I think we're happy with the results we saw coming out of the election. We do have a few questions in the chat. I'd like to read them all. I'll read them off to you. First, Bob Bosca states, I've read that evangelical Christians are 25% of all registered voters, and because of their views and behavior toward mainstream media, including polling, they may be the main cause of increasing election polling errors. Your view?
I think there'll be a lot of deep dives into what went wrong with the polling, in the second presidential election within 4 years. I mean, I was gobsmacked by how wrong the polls were again, and it was so disheartening on election night to come to the realization that the blue wave was not going to materialize. I do think that there's a subset of voters who will lie to pollsters, and that the pollsters are not they're not taking that into account when they're showing the results. I'm not sure if it's evangelical Christians or if it's just those who want to see liberals weep, build our hopes up and then dash them. But there certainly is clearly a subset of the electorate intent on telling pollsters the opposite of what they intend to do. So we shall see. I think there's going to be real dissection of what happened, and hopefully a repair so that these polls can be relied upon going forward. Because otherwise, we're going to be in this situation each election.
So another question from Andy, who states, and Andy, I'm not going to try to butcher your last name. I always have trouble with it. So you're just Andy. When the lawyer for Fulton was asked why a church couldn't discriminate against interracial couples, he said that the state had a compelling interest to prevent this, but the state had no such interest with same-sex couples. How will this be addressed?
Well, the High Court has never said that same-sex couples have the same protections as racial minorities do under the Constitution. So it is possible and likely that the court would offer a different level of protection to same-sex couples than interracial couples. It seemed like when I was listening to the oral argument, the interracial couple example came up multiple times, and the side that was looking to undermine same-sex couples' rights reiterated that these were not comparable. That the law would protect, the Constitution would protect interracial couples, regardless of how the Fulton case came out, and that no social service agency could deny foster parent approval to a couple simply because it was interracial. Well, if you know anyone who's not a lawyer may not understand this, but the 14th Amendment to the Constitution that provides equal protection of law has different categories of protection, with racial differences being the highest level of protection. Gender differences being a lesser category of protection, and that's been established for decades. And I wouldn't be surprised if the court makes clear that same-sex couples fall, more into the the intermediate level of protection.
Mhm. I have a question for you, more of a saboteur question. What stops organizations such as CFI, AHA, or other groups similar from pursuing special treatment for our beliefs that are being afforded to religious groups?
Well, we're not a religion.
Oh,
CFI, so CFI and the secular humanism within CFI has been very clear over its existence that humanists are not a religious group. I know that AHA and some humanist groups have taken a different tack and have declared themselves to be a belief system. And if that it gets pursued, it is possible, I think, for those interests to be protected under that rubric. I mean, that's the whole hoist on your own petard approach of the Satanic Temple, right? Isn't
yes.
that, it's like a total joke, but they're demanding the same benefits, protections, and advantages that religious institutions are being given for their own, their own monuments and their own, the Satanic Temple coloring book gets distributed in school if you're going to be distributing religious texts of any kind.
Mm-hmm.
And it really, it's like a wonderful mischief as far as I'm concerned.
Well, we got to do something for mischief. But a more serious question from Charles is, what do you expect from the Biden administration on this issue, separation of church and state?
Oh, well, I expect them to consider us a secular republic, a secular democracy, and that the law that applies to everyone also applies to religious people and religious businesses and religious groups, which is what the Obama administration's position was. So I don't think Biden will be any different from what you would expect from a typical Democratic administration. They certainly wouldn't be on that side of the Fulton case, the side that says that Catholic social services can use tax money and still discriminate against LGBTQ clients. So I'm really hopeful that, look, the High Court is going to be against us, and we're going to see the unraveling of many precedents that had kept religion separate from government, but we won't have an administration that's pushing those limits the way we do now.
Okay. Another question from Andy. From a secular viewpoint, should a person selling his creative services to the public be compelled to do so for something he finds disgusting, be it satanic rituals, Christian rituals, gay marriages, or others? Is the only recourse to end the business?
Look, public accommodation laws basically say if you want to be in the stream of commerce, you have to treat customers equally. You cannot discriminate against them because of a category that you find objectionable. And I feel as though that has worked very well for us. We don't have hotels that refuse African Americans anymore. We don't have restaurants that refuse to seat African Americans. We don't really want to live in a country like that. I understand that there are free speech interests with regard to being forced to create something on behalf of an entity that you find despicable. But we live in a country where public accommodation laws override that interest.
Mm-hmm. Thank you. I don't see any more questions in the chat or any hands raised. Does anybody else have any questions for Robin? If you do, unmute yourself and ask the question.
Kevin, you had your hand up?
I don't see
You need to unmute yourself, yeah.
Okay. Robin, could you comment on the concentration of Roman Catholics on the Supreme Court and in the Trump government? I mean, Bill Barr's a rabid Catholic, so is Pompeo, and there's others whose names I can't think of right now. How does that affect what's going on with the Trump government?
It didn't have to affect any government or any court. I mean, Sonia Sotomayor is also a Catholic. But there is a strain of Catholicism which is looking to impose its dogma on the rest of us through operation of law. And that is where the fight against abortion rights, against contraception, against same-sex marriage, against the right to die, those are all public policies that derive from Catholic dogma and Christian dogma. And so when you handpick a jurist to be on the religious side of those issues, you're going to end up often with a disproportionate number of either evangelical Christians or Roman Catholics who come from that strain of Catholicism. I don't know if everyone watches Bill Maher on HBO, but he had a wonderful editorial a couple of weeks ago where he talked about, two types of Catholic, the scary kind and the not scary kind, and basically that's what we were seeing on the Supreme Court, because as I said, Sonia Sotomayor is Catholic, and she is now the strongest voice on the court for church-state separation, even stronger than Kagan and Breyer, who are both Jewish. But it is strange that this is the first time in the nation's history where there is not a single Protestant sitting on the US Supreme Court.
Andy, you raised your hand.
Yeah, question. Has a concept of true believer ever been resolved by the court, such as an employer claims he's a religious, or the Satanic Church claims it's a true religion, or even a Christian church where the believers, you see a lot of these ministers are really aren't, they're just in there for the money. Has that ever been tested?
There have been cases like that, and they typically involve prisoners who want special benefits for a religion that they've created, like the Church of Filet Mignon, where they say, part of my religion is that I get steak on Fridays. So the courts have gone through a process by which they evaluate whether a religion is real, whether beliefs are closely held, whether they're legitimate. And I have a feeling, the Pastafarians, the Church of the Flying Spaghetti Monster, there are now cases out there where they've tried to wear colanders on their head for driver's license photos, and they claim it's part of their religion, the way you would wear a turban or a yarmulke or a hijab. And they lose because the court says, look, this isn't a religion, it's satire dressed up as religion.
So does it?
I see the courts, making those distinctions, and perhaps down the road, the Satanic Temple will be the recipient of that kind of ruling. We shall see.
So that type of ruling is not based on the number of claimed adherents, it's more based on the court's interpretation of whether it fits into their view of religion.
Exactly. I do think when a when a religion gets the IRS to approve it, not as a nonprofit, but as a religion, that serves their interest in legitimately claiming standing as a religion. So that's, Scientology famously got tax exempt status as a religion. So, the courts really can't second guess at this point whether it is a credible religious faith. But I'm not actually sure whether the Satanic Temple has that. I think maybe it does. I think maybe it does have standing with the IRS as a religion, which would go a long way in shielding it from a court claiming otherwise.
Okay, does anybody else have questions for Robin?
Judy? You have to unmute yourself, Judy.
You're unmuted, Judy.
Oh, okay.
So when I don't see you raise your hand, because if you raise your hand in the window, I don't see it.
Oh, okay. I'm unmuted. What effect will the Pope's statement regarding gay couples have on the outlook of the Catholics on the court?
Judy, I did not hear that. I'm sorry.
What effect will the Pope's statement regarding gay couples have on the Supreme Court rulings regarding gays?
I think none.
None.
My sense of the justices who are opposed to same-sex marriage, that the Pope is not going to influence their point of view on this. I wouldn't be surprised if the Catholic Church is heading for some kind of schism over this issue at some point. But as far as, Justices Thomas, Alito, Gorsuch, Kavanaugh, John Roberts, and Barrett are concerned, the forcing businesses, people, organizations to accept same-sex coupledom is a violation of their religious liberty, because they themselves are so personally offended, I think, by the fact of same-sex marriage. I don't think that said, I don't think the decision, the ruling that granted same-sex couples the constitutional right to marry will be overturned. I actually think that is safe from having the court reverse that game. But they will do whatever they can to limit the obligation of, people and businesses to accept the result. And that may even go to, clerks of court who refuse to marry same-sex couples, giving them the right to refuse as a matter of conscience.
So they disregard the Pope, who's the head of the Catholic Church, because of their personal interpretations.
I can't imagine that this dictate from the Pope will be changing any minds on the US Supreme Court, despite their, I guess, sincerely held belief that the Pope is the conduit to God. And
Right. So God's conduit is wrong, according to them. Right, okay.
So I don't see any other questions from anyone. Robin, I do want to thank you. Reminds me of this whole thing, reminds me of something that too many conservatives, my impression of conservatives for a long time is they know what's right in their lives, so they think that's the way everybody else should live. And unfortunately, I feel that's your presentation today kind of reinforces that in my mind.
well, it was delightful being with you all today, especially in such a happy weekend.